What's going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chucky, how do you say?
Eat your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you're having a great night so far. Happy Wednesday. Happy Hump Day. Hope you guys are all doing awesome. I've got some court. I do. I've got a bunch of court tonight. Let's see. Well, the theme of tonight is judges getting angry. I've got 3 clips of judges getting angry, and then I got a couple clips at the end to change pace a little bit. But the first one's with Judge Shackleford, and I will say a trigger warning. I'm gonna have to put out a trigger warning. The crimes that this guy is charged with are very severe, and they're against a child. So just letting you guys know. And it also this case might also make you guys angry as well, just as angry as the judges. So that's the first case. Wanted to get that out of the way early, so we had time to recover from it. Real quick though, I want to respond to something somebody Alan. Uh, yeah, no, I saw that, and that's not a new one. That's one of his old arrests. I believe that's Scooter Gate. So that's the case that I had the jury trial for. I believe. I haven't watched the whole clip from start to finish, but Eric Martin's wearing summer stuff. Like he's a tank top and shorts, so I don't think it's new. But I did ask Mike if he cared if I used it, and he said that I could. But I since I already kind of have plans for the next 2 days, mainly Friday being Team Skeptic that I need to get ready for. I probably won't do a video on it until this weekend or early next week. But yeah, if you guys want to check that out, go check out Bama Mike's channel. He's got the Eric Martin arrest video, and yeah, it's from the little I saw, it's awesome. All right, I think that's it. All I had to say. You guys ready? Um, Again, trigger warning for this very first clip. It's about 10 minutes long with Judge Shackleford. If you need to bow out and come back in about 10, 15 minutes, I totally understand. But I just wanted to let you guys know that. All right. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
All right. So we're here today for a competency hearing. And we had 2 reports. We had the initial report from the Forensic Center. And then the prosecution requested an independent, which was granted. And we received a report from Dr. Shazer, a forensic psychologist, and his report on competency as well. Have both parties had an opportunity to review both of these reports?
The people have, Your Honor. The defense has also, Your Honor.
Okay, so both reports indicate that the defendant is not competent to stand trial because of his language barriers, because he is hearing impaired and apparently does not know sign language. And both opinions of both psychiatrists or psychologists were that his ability to become competent could not happen within the statutory time frame required under Michigan law. Is that your understanding of both reports?
That is the people's understanding. That is also my understanding, Judge.
Okay. So are the parties stipulating to those results?
The people would stipulate to those results, Your Honor. I believe that because there's no mental illness and no intellectual disability, which were found by either Dr. Thomas Shazer or Dr. Stephen Shostak, that the people could not petition for the Wayne County probate to take over. And we would stipulate to the results in this court.
Yeah, that's my understanding of the law as well. I reviewed the mental health code as well as both of these reports, and when both doctors are saying that because he doesn't have
I am 100% deaf in my right ear, and my left ear isn't 100%. I don't know sign language. It's been something I've always wanted to learn, and I really probably should. But when I don't have headphones in, I can barely hear. Just ask Heather, or Sly. Sly's in the chat. She's been with me in person. I'm I am mostly deaf, and you can tell when you meet me in person. But yeah, no sign language here.
Issue that can be fixed basically with treatment, that he can, competency cannot be restored.
That is correct, Judge. It's my understanding that he is unable to assist in his defense due to his lack of expressive and receptive, communication, and that there's likely no possibility that would be restored.
All right, you two can be seated, if you want, if you're more comfortable. Look, this is one of the most alarming
Yeah, peeps, I'm not gonna lie. When I saw you in chat, I was kind of expecting you later when Bacon was finished. So I didn't think that I was gonna have to let you know, but I knew that you wouldn't want to watch this.
situations I've had come up, both as a defense attorney, as a prosecutor, and now as a judge. I have an individual before me who, I did the swearing on this case. It's alleged that he had a minor that was essentially under his control and authority, who resided in the home with him, who looks to him for care and other types of, he's essentially a guardian of this child, right? And he took advantage of that. That's the allegation. The allegations are that this man, Mr. Murray, sexually assaulted a little girl for years. And the sexual assault was I'm not justifying any level of sexual assault, but the sexual assault in this case was actual penetration of a child. Vaginal sex with a kid. And what's alarming to me is there's a confession. He admits he did it. And where we're at now is I have a person in front of me who was able to be married. He can clearly communicate to some degree because he's able to have a marriage, which means he was able to court somebody and go on dates and communicate effectively with them to have some sort of relationship. And then he was able to work in some capacity. He's able to be employed. He's able to pay bills. He's able to have a home. So he's competent to do everything else in the world except for stand trial for raping a child. And I have no authority under Michigan law, and I've reviewed it, and we had a lengthy discussion in chambers. I have no authority under Michigan law to do anything about it. And it's repugnant. And I understand these are allegations, and I respect that everyone has a right to a trial, but the miscarriage of justice, when we say people have a right to trial, it's not just the defendant, victims have a right to a trial. And I have a minor victim in this case who was put up with allegedly years of sexual abuse. The trauma that comes along with that it's appalling. And this child, according to the allegations, did what we encourage kids to do. Finally, she had the bravery to come forward and tell someone. She did exactly what we all go home and tell our kids we want them to do. If something happens to you like this, or somebody touches you inappropriately, tell. And it takes a lot of courage to do for a kid. So this little kid tells, goes to a criminal justice system that is supposed to protect a defendant's rights, but it also is supposed to protect victims and give them some sort of recourse and some sort of justice. And I have to sit here today in a robe that I waited and worked my entire life to get to say that we can't go forward on this case because a guy who understands how to pay his bills, get married, do everything else an adult does in life, doesn't understand what's happening enough here today to assist in his defense, and he gets to walk out of this courtroom with no consequences for these allegations. And this is the most difficult thing I have ever done as a judge and will likely ever do, because there is a child that is getting no justice. There is a family that is irreparably damaged. This will affect her for the rest of her life. And we all know it. There's studies on it. There's nothing. Her sense of safety, I can't even fathom what I have to do here today. And this loophole in our criminal justice system that somebody who is accused of one of the most egregious crimes in our society is just going back out amongst us. He's not on a sex offender registry. Nobody's going to know that this man has been accused of these allegations. And that this young lady has absolutely no recourse.
Yeah, Jed, for everyone that came in late, I'm not going to recap too much because I don't want to really talk about what's going on. So the defendant here had SA with a child, and he was found not competent, so they have to dismiss the case. So this is Judge Shackleford being very angry that she has to dismiss this case, and she even just said she spent a long time going over the Michigan state law to see what she could possibly do, and she can't do anything. It's sad. It really is sad.
In the criminal justice system, it's just unfathomable. And the idea that Mr. Murray is sitting here today and he can't understand everything, but he understood how to manipulate, allegedly, a little girl and sexually penetrated a little girl it's the most extreme miscarriage of justice I've seen in my 20 years of practice. 20 years, only criminal law. I've never seen anything as appalling and egregious as what we're doing here today. So there's no way to proceed on this case. Ms. Krause, you have a job to do, right?
Yes, Judge.
Are you asking the court to do anything?
Yes, I'm asking the court to dismiss this case against Mr. Murray since he is not restorable to competency.
I have no choice. I have no choice under the law in the state of Michigan. Hopefully somebody from somewhere will look at this and address it with the legislature or whoever it needs to be addressed with, because it's terrible, absolutely terrible. Mr. Murray, you go near that little girl, you'll find your way right back here. And we'll go through this all again. And you know what I'll do? I'll lock you up with no bond while the case is pending, and we'll send you for another round of exams. See if you understand anything then. Disgusting. Case dismissed.
Thank you, Judge. And there is a no contact order, Your Honor, because there is an ongoing open CPS investigation. So just as a reminder, he is still being investigated under the Child Protective Services.
That is correct, Judge. The CPS case is still open and pending at this time. It's my understanding that there is no contact order. He is not allowed to return to that residence. I would just ask the court to remind Mr. Murray of that as well, of the CPS case.
Mr. Mur-
I was reading the chat. Did she say dismissed without prejudice, or did she just say case dismissed? I don't know. I don't know if they can refile this if they're dismissing it because he's incompetent and not restorable. I don't know. Maybe if he goes to another exam later because he commits a crime and he's found competent, maybe they can recharge it. I don't know. This isn't really an area that I'm too familiar with.
Murray, you are not to go to that residence. There is an order through CPS. You're not to go near this child. Oh, you understood that. Didn't you? Yeah, you. We're on recess. You,
All right. I wanted to play that one first. That way we have the rest of the night to recover from that. And Jedi, he doesn't know sign language. They didn't say that he was incompetent because he's hard of hearing, but they use that as a reason why he is incompetent. But I'm sure there's a lot more reasons. If it was just his hearing, I'm sure they would have figured out a way around it. It was just one of the, I'm guessing, many factors. All right, JP, absolutely. Let's just move on. We got Judge Dad next, and yeah, we need to laugh at somebody, and Judge Dad getting angry with someone kind of dumb. It's always funny. Let's go.
Young guy, so I figured that must be you. Devin Margaret Sessoms, 24F242601. And I'm going to need Beth Wiles in here, please. Can somebody call Beth? Good morning. Your name?
Devin
Mr.
Margaret Sessoms.
Counsel?
Good morning, Your Honor. Christopher Shemke, appearing on behalf of my clients. Time, we are ready to proceed.
So she didn't show up yesterday. She was supposed to be here.
Shemke!
Yes, Your Honor, I spoke with her. In that circumstance, she was able to make contact. Ms. Wiles called her. She's apologetic for not appearing as soon as she found out she had today's proceeding. She walked in today on her own volition, and we are prepared to address the violations.
All right. And is that right?
Yes.
Where in the world is the probation violation?
Your Honor, I saw that it was alleged that she had missed a court work program on January 18th, and then I believe there was some subsequent testing that was missed. I saw that there was indication when I looked through the documentation that it was court work program, and then when I spoke with Ms. Wiles this morning, she told me about the test.
Tell them I need the probation violation, please.
She's unaware.
I know, tell her I need the probation violation, please. It's not in the file.
I don't really think that was the attorney. The attorney can recommend a person for an evaluation, but they don't have any say over what the results are. I mean, maybe. I don't know. I don't know.
Yeah, so.
Let me go on to a couple of these others, okay? I will not be long. Just have a seat right there. Brenda Lynn Perry, 24I414-864.
What's up, Lone Wolf? I didn't edit out this little break, but it's only about a minute long. So
Where
I
is
didn't
Ms.
even bother
Perry?
with it.
Is she out there? Is she out there, Lisa?
No, she's not
All
on.
right, I need to all right, let me figure something out. Devin Margaret Sessoms, let's recall that. Give me that. tab. 24F242601, thank you. All right, there it is. All right, Mr. Shemke, your appearance.
Good morning, Your Honor. Christopher Shemke, on behalf of my client, who stands to my immediate left.
Ma'am, your name?
Never mind.
Ms. Wild, your name? Here are the charges. Failure to attend the court work program, January 18th. Failure to submit to twice weekly testing on January 18th. Failure to provide proof of completing 6 hours of community service by January 15, and failure to attend outpatient treatment, missing several sessions of treatment between October and January of 25, October of 24, January of 25. How's she going to proceed on these?
Your Honor, we're not going to be contesting the violations. We will admit responsibility with an explanation.
So if you plead guilty here, I want you to understand you have 2 prior violations. This would be 4 more. You could be incarcerated on this for up to 93 days. Do you understand that?
Yes.
Did you sign an advice to rights form today? Nothing's going on right today, right now. You're presumed innocent. They have to prove you guilty by a preponderance of the evidence on these. You have the right to a hearing. You have the right to question their witnesses. You have the right to remain silent. If you remain silent, I won't hold that silence against you. You plead guilty, you're giving up your right to a contested hearing. You're waiving your right to a hearing of any kind. You're waiving the right to cross-examine probation witnesses. You're waiving your right to the presumption of innocence, so to speak, because they have to prove you guilty by a preponderance of the evidence. And then I would sentence you after plea if that's the way you choose to proceed. Do you understand everything I just said?
Yes.
Do you want to,
It's on your desk.
or do you still wish to plead guilty to these?
Yes.
As to count 1, failure to attend the court work program on January 18, 25, how do you plead?
Guilty.
As to count 2, that you failed to submit to twice weekly chemical testing on January 18, 25, how do you plead?
No, I did go to the 18th. But I went to the later one at 7 p.m. They gave me this card.
Slow down, slow down. You can't whisper. If you don't want to plead guilty,
I went
hang
to
on, don't say a word. If you don't want to plead guilty, you don't have to. If you think you went twice, if you think you went to testing on January 18, that's fine. Do your records indicate she went?
I am not aware that she went. She did not speak with me at all in regards to or communicate with me about her mess or where she went. I would have to look into a different system. We have her no show at her usual site of DNA on it.
So, Your Honor, at this time, we would at least admit responsibility to the failure to make the court work program. I'd ask that we.
I'll have a hearing on that. As to count 3, that you failed to provide proof of completing 6 hours community service by January 15 of 25, how do you plead?
Guilty.
Did you fail to provide proof of that? Did you fail to provide proof of that?
Yes.
Count 4, that you failed to attend outpatient treatment, missing several sessions of treatment between October 24 and January 25. How do you plead?
Guilty.
Did you miss several treatment sessions between October 25 and October 24 and January of 25?
Yes.
Anybody force you to plead guilty?
No.
And you're telling me you went on January the 18th for testing?
Yeah, I went to the place,
Just tell me the name. You got a card there. I can't read it from here. Where?
A progressive drug, P Dams. And it's the place that's in Detroit. It's on the sheet that you gave me.
There's ASDC
That's
that,
what it was, yeah.
that she could have gone to. But again, I would be unaware if she went there since she didn't communicate with us until Wednesday, the 20th.
I'll enter a not guilty pleas to count 2. Anybody force you to plead guilty as to counts 1, 3, and 4?
No.
I'm accepting your pleas. I've got real concern on that. I don't know what's going on with you. You're not taking it seriously. I'm ready to pull the plug on the whole sobriety court deal with you right now. You're not mature enough to handle the program. You're not mature enough to handle this program. I mean, you might be the most sober person in the country, which I'm having my doubts about, and you're not complying with the orders of the court, but you're just not mature enough, Ms. Sessoms. I hate to tell you, I saw this one coming. I took a chance on you, and quite candidly, I'm not sure I don't want to just end this whole little charade today. We got too much going on, too many people that we want to help, too many people that want help. You couldn't do your community service? I mean, look, I sent you October 16th. Actually, it wasn't. Was it 6 hours or that's a typo? Did she do
The
6?
6 hours are the sanctioned hours from her last violation. When I last spoke with her, she didn't have hours done at all, but she does have her original 48 due February 1 here in a couple of days.
And then she doesn't show up yesterday. I tried to tell you nicely here. I have tried to tell you nicely. We're not playing baseball here. If we hit 360, in other words, if we're compliant about a third of the time, they'll pay a baseball player 32 million. Here you're gonna end up in jail. I'm serious. I don't know what to do with you anymore. I've tried to tell you nicely at these status reviews, you gotta pick it up, but you don't show up yesterday.
I was unaware of it yesterday. I would never, ever intentionally miss a court date.
Do you know anything about that? Did she tell you that?
So we told her that she would have a court date. We did email her notice, since we don't have the mailing, the 10-day
Never
notice.
saw that.
I did try calling her, and I didn't even get
Fine,
voicemail.
I won't hold that against you. But all these other things, I don't know what you're doing. And you're gonna force me to do something I don't want to do. I don't think you're cut out for sobriety court. I mean, honestly and truly, we got how many in mind? 32 or 4?
32, Your Honor.
Well, I gotta tell you, if I was ranking them easiest to deal with, toughest to deal with, you're in the bottom 2. That doesn't put you in a very good stead. It's nothing personal. I just don't think you're mature enough to handle the program. I mean, there's people like that. They just irresponsible. I don't know what to tell you. I mean, I thought we did a better job of screening and making you understand we expect 100% compliance. And you don't seem to be bothered when you're violating. That's the other thing.
It bothers me.
Well, not enough.
Sir, can I?
Go ahead,
Say
Mr.
something.
Yes,
What do
Your
you want
Honor.
to say?
As to the 18th, Judge, she indicated that she did go to the doctor on the 17th. She told Ms. Wiles that she was not feeling well on the 16th. She did have some blood drawn taken. She did bring results in today. She indicated that she's actually quite low on her red blood count, a red cell blood count, and she's going to be going to a further specialist. This might have to do with excessive fatigue and dizziness and potentially distracting her from complying with terms and conditions. I've encouraged her to get whatever sort of treatment she needs, because obviously if it's something that's precluding her compliance and it can be remedied, it would be something that I would consider asking for some leniency. Furthermore, she indicated that she has maintained her sobriety. She does indicate that she takes this seriously. She has responsibilities as a stay-at-home mother. She has a 5-year-old son, and she does receive some assistance from her mother in Monroe. I believe that she started off maybe not on the best step. It's my hope that potentially she can get whatever medical issues that she had to go forward without any further
How
complications.
many sessions did she miss of treatment? Do you know, between October and January?
Yes, Your Honor.
I mean,
So in the month of October, she was supposed to attend group sessions. Those are once a week. She did not attend any in the month of October. She did not attend any group sessions in the month of November. She canceled an individual appointment in November on November 8th. In December, she did attend her group therapy. She canceled 2 sessions of her individual therapy. In the month of January, she was a no-show on January 10th. She canceled an individual session January 17th, but she did attend 2.
All right. If it lagged, do I need? To rewind it? Are you guys locked? This isn't good. This isn't good. All right. Are we back? Are we back? I'm talking. I hope I'm not muted. My internet's saying it's low. All right, I'm back. Okay. Maybe it's StreamYard. He uses StreamYard too. Don't touch anything. I haven't touched anything. Well, besides chat. I'm waiting a little bit. I'm just waiting. It's still saying my internet connection is really low, but if you guys can hear me, it might be okay. So I'm just gonna play it, and let me know if there's any issues on your side.
Of the groups. Again, she's supposed to be going weekly, but 2 of the groups in the month of January.
Sir, my dad died in October.
I'm sorry about that. I really am.
I have had a hard time since I started this program.
We'll try to explain it to me so we can help you. We can't help you if you don't show up and you don't tell us. Now, that is understandable. Losing a parent, especially at your young age, it's very difficult. I lost my father when I was very young. In my 20s. It's not anything we should have to deal with. I get it. But you got a problem here that you have to deal with. If you don't deal with it, it's going to get worse and spiral out of control. And if it spirals out of control, what's going to happen to your son and what's going to happen to your life? Let me see the screening report again, please.
Yes, sure.
We're not mean people here. We're trying to help you, but there's accountability and you're not being accountable. You had 2 of these within 3-4 years, and this one you had a 0.265 and 253 on it. All right, what else do you want to say, Mr. Shumke?
Your Honor, just that my client does appear that she's sincere and contrite with her willingness to try to demonstrate compliance with the court. I know that she did not begin on the best step. I know that she's had some challenges. I'd ask that potentially we have a review so she can demonstrate full compliance, but I think that if that were even to be permitted, which we understand would be a significant allowance, I think that she is of the understanding that she, if was granted this, has run out of slack, and that any potential violation or even allegation there could result in termination from the program, continued revocation of her license, and potentially other sanctions, including but not limited to jail.
Have you worked since May?
No,
Why?
I just stay home with Hudson.
Well, I thought you said your mom watches him a lot.
Only nowadays. But when I have these court things.
What do you think?
I'm not sure, I have talked to Devin, I'll give her credit, she really does try to stay organized, I will give her a lot of credit there, she has been color coding, she's using her planner, her diagnosis of ADHD sometimes will get in her way. Again, to her credit, she did use her SoberLink throughout this time frame with the miss, and she was all negative on her blows on the SoberLink. But I don't know how else to motivate her to make sure she's communicating, with these misses. I didn't hear from her until we had status review on Wednesday. I've talked to her The reason why I didn't violate her earlier on her treatment attendance is because of reasons that she gave you. There was the death of her father. We tried to work with her on organization. The guidance center tried to work with her on that. It's just come to the point where when, especially this month, a no call, no show appointment kind of triggered that violation in itself.
Anything else?
I mean, just the fact that I had to stop taking my medication that I was on for years, and I'm still getting used to another one, my ADD medication. That's been hard too. That's it.
How were you able to work in May of 24? You said you're not working because you're watching your son, but you were fired from your job in May of 24. How were you?
February.
Pardon?
February.
Okay, well, you initially told probation May, but that's fine. Whether it's February or May, how were you able to work then and you're not able to work now? Who was watching your child when you went to work?
He was in daycare. But it was like $800 a month, so.
I'm so close to sending her to jail. I think you need to go to jail today. And I'm not trying to be mean. I think you need a wake-up call. Listen to me.
I do not, sir.
I'm sorry.
I just needed to get my.
Listen.
Sir, I wake up every day dizzy. My red blood cells are so low. I have an appointment with a cardiologist. I have a follow-up with my doctor on the 6th.
Have you seen these medical records?
I have not.
I can show them to you right now. You told me to bring them, I brought them.
I don't think you're going to make it through this program. I don't think you will. I'm sorry. I'm going to keep her on probation. If there's anything in there that you think will enlighten me, I'd like to see it.
Yeah, she is provided proof of her blood draw results. It does appear that she has an appointment with a cardiologist on February 24th. The other information I'm still going through, but it does look like perhaps she's being tested even for POTS, which again is a heart condition. As far as the other information, I think that it just goes into reasons for the low blood and tests that she's going to have done in order to determine why her red blood cells are so low.
I'm sorry. You're going to jail today. I'm keeping her on probation, subject to all existing terms.
What?
3 days jail, have a seat. I'm not going to argue.
No,
Have a seat. No,
please.
you need a wake-up call. I'm sorry.
I don't.
Ma'am. Have a seat. Have a seat.
Please, no.
Have a seat.
I do not.
This way.
I'm not going to argue with you.
Come on.
Amir Fadil El Maradi, 24B144695.
There you go. You're going to jail today. Yeah. She got 3 days. She could have gotten a lot more. 3 days will be a wake-up call for her. Hopefully that's enough. Yeah, but she's barely doing anything, and the judge wasn't wrong. She's not really cut out for sobriety court, and if that's not the case, that's fine. But she's gonna have to, grow up and serve her punishment or her sentence. I guess I shouldn't say punishment, sentence. All right, let's move on. Next case. Next case we have. Actually, before we go on to the next case, I've got some super chats. Whatever kind of cat that is. Meadow. Yeah, no idea. Cheshire Cat, thank you so much for the super chat. Those fire tech skills I working. That wasn't my fault. That was the internet. My internet just dropped. I didn't touch anything. But yeah, you can blame me. I'll take the blame, especially if you're sending me super chats for it. And Cheshire Cat, again, will you get upset if I have fun with you? No, absolutely not. He's a grown man. He can take it. You can have fun with him if you want. He might not answer you, but you can have fun with him. Also, I've got a PayPal from MB. MB, thank you so much for the generous PayPal. I appreciate it. It's always good to see you. Thank you so much, MB. I do appreciate it. You're awesome. Okay, now we're moving on. We're moving on to Judge Webster. Some of you may have seen this yesterday. This is what happens when you upset Judge Webster and you're the prosecutor that upsets Judge Webster. I'm not going to say anything else. Let's go.
There it is.
Will the prosecutor be joining us? Let's go on the record.
Anytime, Kim.
It is now 11:01 a.m. We are on the record in the 13th Judicial District, the District Court of Greenwood County, Kansas. Please announce appearances.
The defendant, Mr. Moller, appears in person with counsel Christopher Ambrose, Fargus Legal.
Yeah, it's Joe Gillette. That's who the prosecutor is.
I see a picture of County Attorney Jill Gillette on the screen, and it says County Attorney Office, but we don't have a prosecutor today.
Judge Jill is in a special setting Elk County trial. She found out on the 15th, 16th that this would be taking place with Judge Ricky, kind of a high profile case down there. And so we started putting in place the replacement or continuances that might be on contested hearings on the 17th of January. This is the only one that was not resolved.
And Judge, if I may,
Just a moment. All right, so the person speaking is Jessica of the County Attorney's Office, is that correct?
Yes, Judge.
Now, at 10 o'clock, a hearing was called and we had a pro tem. You're saying that pro tem is not available?
That is correct. Ms. Gillette did not have Ms. Oliver on for this hearing because she had already taken the steps to do the motion to continue, where we might even in most cases just get a date by email prior to the hearing setting. And I checked in last week to see if that was going to be the case as well. I have been trying to work on this, but Ms. Oliver is not prepped for a contested hearing today.
This hearing was set November 22nd, 2024. Both parties told me they had the date available. Now, I do see that a motion for continuance was filed, but it was never brought to my attention, as I recall, until this morning when I was preparing for this hearing, that wait a minute, I've got the wrong case called, just half a second. Clicked on the wrong one. Yes, November 22nd, 2024, this was set for evidentiary prelim. And both parties did tell me they had today's date available. And then there was apparently a motion to continue filed by the state. But that motion was not heard. That motion was to continue was filed January 23rd, 2025, which would have been 5 days ago.
Is that the e-file date, Your Honor? I just want to verify, or the date that it got sent to the queue. I don't know if we can tell.
Just tell you that's the date it was filed. Whether it got to my queue or not, I don't recall. But that's the last document.
Yes, peeps, you're safe. That hearing ended about 25 minutes ago, so you're more than safe.
It was a motion filed 5 days ago. And it simply says, comes now the state by and through Jill R. Gillette, Greenwood County Attorney, respectfully requests a continuance alternate date for the motion hearing currently scheduled for January 28th at 11 o'clock. So the motion hearing apparently was intended to be today. Prosecutor will be in Elk County. Certificate of service says that on January 25th, the true and accurate copy of the above and foregoing was mailed to the following: Honorable Judge Webster, and sent to Richard Paw, attorney of record, and he is not the attorney of record.
Yeah, that would have been a mistake. I do remember yesterday, Judge, I wish Jill was here to clarify some of this with us, that she mentioned her and Chris had been discussing this case, but she never told me a resolution, a plan. I didn't know if Chris had an update on their discussions.
Well, last I knew, the judge granted continuances. That it wasn't granted by prosecutor, by defense attorney, and then just dropped in the day of hearing and said, oh, by the way, Judge, we agreed to a continuance 5 days ago.
No, I understood. I guess I meant maybe a waiver or stipulation, Your Honor. I'm sorry, I don't know what they were discussing.
All right, well, you're getting the brunt of what your boss did or didn't do, Jessica. I understand the situation that you're trying to do the best you can in. All right, Mr. Ambrose, you wanted to address the court. Go ahead.
Yes, Your Honor. Ms. Gillette had been in contact with me about this. I had attempted to get in touch with Mr. Miller, and we had evidently had some problems with that. If I could have just a couple minutes with him, we might be able to, I can hopefully give the court some more guidance. And then we could take care of that if the court would allow us to.
Judge Webster is a Scotch person. I see it. She just sits back there with her single malt, just enjoys her Scotch. Maybe even a cigar too. I could see that.
Well, I don't know that I need guidance, but I will grant you.
At least our position. Let me.
I will grant you the breakout room. Thank you. Missy, if you would please put Mr. Ambrose and the defendant in a breakout room. We are back on the record in Greenwood County 2024 CR 140, State of Kansas versus Wayne Allen Moeller. We still have no prosecutor. We do have back with us Chris Ambrose, defense attorney, and the defendant, Mr. Moeller. Jessica, what's your official title down there?
Legal assistant, Your Honor.
Thank you. Legal assistant. All right. You know, in all the time I've known you down there, I wasn't sure. All right. And we have no prosecutor because Miss Gillette is tied up in an Elk County jury trial, correct?
Yes. Started, I believe, this morning at 9 a.m.
Okay. All right. Mr. Ambrose, you've had a chance to talk with your client. Are there any new developments from your side of the case?
Your Honor, I spoke with him, and in light of kind of the situation that Ms. Gillette's found herself in, we don't have an objection to continuing this. We'll get, if we could just get a new date set, and hopefully Jessica will be able to have a calendar so we could get that set. I'd like to make sure that we have it set for an evidentiary, if she's got a calendar to where we can do so. So we don't have to have Mr. Mueller come back just for a status hearing and sit around for that sometimes long docket.
Well, we better not just have a status conference. I had this set for evidentiary hearing again since November 22nd, 2 months ago. And then I come in and a few minutes before court and am told that, oh, the county attorney continued it 5 days ago without consulting the court. I think it's unfortunate that Miss Gillette is supposed to be in 2 courts at once, but that was the responsibility she took on when she ran for county attorney in both Elk and Greenwood County. She certainly gave the appearance that she could take care of both of us as needed. And now I've been bumped for something going on in Greenwood County. Surely a pro tem could have been called for. I know Judge Hutchison used to appear as a pro tem, retired Judge Hutchison. Mary Ann Shirley, local attorney, has done that. Miss Oliver, who I understand has lots of experience in various counties as prosecutor, assistant prosecutor, was here just an hour ago in a case. And Assistant County Paul Dean helps cover the cases. So I'm just really put off that, first of all, a prosecutor would take it upon herself to just decide she didn't have to be here and she didn't have to talk to the judge about it or work it out. This case involves very serious charges. Count 1 is unlawful distribution of controlled substance. The defendant is accused of a level 2 drug felony, allegedly possessing back on July 26th, 2024, approximately 54 grams of the controlled substance methamphetamines. In count 2, he is accused of on that date also possessing fentanyl, a level 5 drug felony. In count 3, he is accused of possessing paraphernalia to help manufacture, cultivate, plant, propagate, harvest, test, analyze, or distribute controlled substance. Count 4, he's accused of an aggravated weapons violation by possessing an AR platform rifle while having been convicted as a person felony under Kansas law in an aggravated battery case out of Sedgwick County. In count 5, he was accused of the felony charge criminal carrying of a weapon to wit a shotgun with a barrel less than 18 inches in length. He was accused in count 6 of having an amount of drugs that required a drug dealer tax stamp, a felony. Count 7, he was accused of defacing the identification marks of a firearm, intentionally changing, altering, removing, or obliterating the name of the maker, model, manufacturer's number, or other marks on a 12-gauge shotgun. Excuse me. Those are the felonies that I was to hear evidence on today and to determine if there was probable cause to believe these crimes took place and that this defendant committed them. The defendant does have the right to a timely preliminary hearing, and we are well beyond timely, being these allegedly occurred July 26, 2024. I also noticed in preparing for this case today that 2 Greenwood County Sheriff's deputies had been subpoenaed. They were subpoenaed clear back December 6th for today. Where are they? Did Ms. Gillette take it upon herself to cancel them, or did they just fail to honor their subpoenas? Does anyone know?
No, ma'am, they would be available if I need them. They're just on standby.
All right, so they were told to be on standby, but not necessarily be here. All right, thank you for that information. Well, I'd like to call them from standby and start this hearing. You don't have any prosecutor available, though. No, Ms. Gillette didn't arrange for any prosecutor to be here? Jessica?
It was my understanding she did not want to impose on another prosecutor to do a contested hearing. She didn't feel comfortable with that. Since these are her charges, she filed them. She wanted to be the one to potentially present the evidence to you herself. Because Ms. Oliver is actually covering the rest of the things today that aren't contested. This was a Mrs. Gillette decision. We just tried to follow through and get it disposed of before 11 today.
God forbid we'd impose on a prosecutor pro tem that's reserved her day and not think twice about imposing on a judge or a defense attorney or a defendant. I don't know why it would be that Miss Oliver, who is experienced, would be more inconvenienced than any of the rest of us. But again, I am barking at the wrong person. Jessica doesn't, as a legal assistant, doesn't control the county attorney. The county attorney doesn't control the judge, although she has today. What's the chances if I set this for another day, it'll go to prelim and Miss Gillette won't cancel it again?
It is my
That's-
understanding that the Elk County trial today should rectify that Elk County case today, so there should not be any other special settings from Judge Ricky. So I do have a calendar available, whatever date you pick, I will make sure she's clear.
Well, I can't believe when Judge Ricky set a case over mine that he either A, knew I had this case going or didn't expect the prosecutor to get with me about it before today. But in any event, I understand there are cases that need to be tried, but there's also protocol on how you continue other cases. So that being said, Missy, what is the next available evidentiary hearing date that you have? Because this defendant and his attorney are entitled to an evidentiary hearing.
What about Friday, February 7th? I have 11 o'clock or I have some time in the afternoon.
Mr. Ambrose, do any of those work for you, or either of those?
What was
I've
that
got-
date again, Missy? Sorry.
February 7th.
Could we look at the afternoon that date? Do you have anything after 2?
We're actually completely open in the afternoon, so we could do 2 o'clock or
Could we
2:30.
do 2? Could we do 2:30 just out of an abundance of caution?
Yeah.
If that would be possible. I'm sorry, I'm in Geary County later that morning. I've got you guys first thing in the morning. I've got Geary after that. And I'd like to be able to drive back to Emporia so I'm not stuck in Geary County until the end of the day and then driving in dark because I'm an old man with terrible eyes.
2:30 works for Jill.
Okay. Thank you.
All right. If that works, I want to make sure you have plenty of time so you don't get penalized for this situation we had today.
No, that'll give me enough time, Judge. That means I have to be out of Junction City by 1 to be back to my office in time. So that's plenty of time.
All right. Mr. Moeller, any reason why you can't be here at that time? Any doctor's appointments or anything previously scheduled?
No, ma'am.
All right, I'm going to continue the bond you are on with all existing conditions. Don't be possessing, of course, any firearms or having any contact with people you've been told not to.
Right.
So with that being said, I think we've covered what we can and we'll be in recess. Thank you all.
All right. I have that date written down. I don't think that Judge Webster is going to say much to Jill on the record, at least on that day. I'm sure that they've already talked about it. If there's going to be any, maybe potential sanctions or any kind of punishment, I'm sure it's going to be off the record, and we're not going to hear it. But I do have it written down on my calendar, so I will follow up to see what happens in that case. All right, let's move on. All right, I've got a treat for you for this next clip, and it's not the case. And I'm going to preemptively say, I don't like making fun of people for things they can't control. I like making fun of people for their actions, but not what they can't control. But when I saw this case, this happened today. When I saw it, I immediately thought, this poor guy. How in the world did he grow up with this name? All right, let's go. This case is just But yeah, look at what this guy's poor name is. Well, look at this poor guy's name is. I'm sure maybe he loves it now, but oh man, kids are mean.
Yeah.
Kind of impressive. All right, this is case number 24RO09076. This is People versus Michael Antonio Hunt. Mr. Hunt, is that you?
Yes.
All right, Mr. Hunt, the court can hear you. Try to find a space where you can remain still and lit for the balance of the hearing. Mr. Hunt, this is your date in court. This is an informal hearing. It's not criminal. Nobody goes to jail today on their ticket, but it's considered serious enough that Officer Keikos did issue the citation on the date in question, which was November the 29th of last fall. At approximately 20 minutes of 10 in the evening, you were operating a tan Kia southbound Main Street at or near 11 Mile Road in the city of Royal Oak. And at that place in time, you committed what could be referred to as two different things saying the same infraction, which is straddling lanes or improper lane usage.
Yeah.
I'm sorry, stay with me for just a minute. The officer's remark indicates followed from southbound Main 11, unable to maintain lane use, cross divider. So the citation is for straddling lanes. You may, Mr. Hunt, admit responsibility in this matter. You can admit and explain.
Oh, the judge saw it. He saw it coming. He made sure he read out the entire name. Like, nope, I am not doing that on the record. Absolutely not.
What you think might mitigate the circumstances, or you have every right to deny responsibility, and we will run a very brief trial. What would you like the court to do?
Well, so to understand, if I admit to it, does that hinder my license or something?
I'm not here to haggle with you, okay? I don't have that authority. I'm just the umpire. But the court is required to take a plea. So, I can accept a plea with an explanation, or we can run a brief hearing and go ahead.
I'll do an explanation.
Okay, so you wish to confirm to the court that on the date in question, you were operating a motor vehicle in the city of Royal Oak and straddling lanes, correct?
Correct.
DeRaw gets it. He's trying to get me to say it out loud. Absolutely. If he didn't get it, he probably would have thought we were talking about the officer. I don't know.
Thank you. Court appreciates and accepts your plea. What do you wish the court to know?
It was my first time like in the area of Royal Oak, and it was my first time driving a rental of that size. I used to drive a truck, but I was in a car accident, and that was a choice of vehicle what I got from my agent and stuff. So I'm not used to driving such a small vehicle. And then it was kind of snowing and stuff, so it was hard for me to visibly kind of see. But I was just trying to make sure I didn't damage the vehicle at all. And it was cars to the right of me, and I was not trying to get close to any of the cars and stuff like that. It was my first time, having a ticket like this, so I'm not used to how it go or whatever. But I admit, yes, I was swerving. I was just trying to get in the right lane.
Okay, thank you, Mr. Hunt. So that the court understands, I think you're suggesting your normal daily vehicle is higher up, and now you're in a sedan?
Yeah, it was like a sports car, like a Kia or so. And then I was trying to drive slowly because it's just like if I would have went even faster, the tires would have been sliding. Like that was the case going there that night. Even the freeway was packed. There was so many accidents. I was trying to avoid it, avoid an accident at that, and then it's a rental too. So, I was trying to be extra cautious, drive slow, and everything. Because on the freeway, I even had to put my hazards on there going I was going to the theater and roll up for my niece's birthday party. And then when I left, it was dark and, stuff like that. So, yeah. So.
I appreciate all of those remarks. Officer Keikos, what, if anything, would you like to share?
I have nothing to say, Your Honor.
All right. Mr. Hunt, as suggested, the court doesn't have legal authority to change points, but what it can do is give you some break with respect to your fine. So please stand by for just a moment. The standard fine for this is $130. The court's going to reduce that to $100 even. That's payable through the pay portal on the 44th District Court website, or you may walk a cash check or charge into this court at 400 East 11 Mile Road, Monday through Friday, between 8:30 and 4:30. And that's going to be due within 14 days. That takes care of your hearing. I hope you got your truck back.
Yes.
All right. Take care.
Thank you. All right.
I told you. I could not let that go. Again, the case was just but yeah, you guys stepped up to the plate and you nailed it. Thank you so much for that. I needed that laugh, especially because I already saw that and knew it was coming. You guys are awesome. All right. We have one clip left. This is a true feel-good clip. It's only about 2 or 3 minutes long. You guys are gonna love this. This is a great way to end tonight, especially after the first clip. Yeah, good palate cleanser. But yeah, like I said, because it's only 2 or 3 minutes long, I'm just gonna let this play out. So let's look who we're gonna raid. Oh, I said we're gonna raid Katie Zed last night. I said that. So is she on? Yep, she's on. We'll go to Katie Zed. All right. You guys are awesome. Thank you so much for the super chats tonight. And MB, thank you so much for the PayPal. That was very generous of you. No, no, actually, this is for real. This isn't a feel good clip, because the defendant did something good. It's a feel good clip. Like you're gonna smile during and after this clip. That's why it's a feel good. It's gonna make you guys feel better. And I promise. I promise. I'm not trying to trick you this time. I wouldn't do that to you. Oh, I absolutely would, but no. All right, you guys are awesome. We are set up to go to Katie Zed. Jump over there, make sure you say hello. And just another reminder, I'm going to be shoving it down your throats until probably should use my words better after that last case. But Team Skeptic on Friday nights. It's going to be awesome. Hope to see you guys there. Normal time. Normal time. All right. Let's go. Let's finish it up. You guys are awesome. I will see you tomorrow. Until next time. Bye.
We would like to.
Okay. Give me just a second to clear off what I have in front of me and then we'll go in the back. All right, counsel, Mr. Beretta, this is 2-4-3-2-0-4, the People versus Pro Services.
For the record, Your Honor, Eric Beretta on behalf of Pro Services. I have my legal assistant with me today. She's assisting.
Oh, I love it. Okay, good. Well, this will probably be just the most exciting day of legal assistance she's ever had, right?
Correct. She likes.
Man, defendants are just getting younger and younger, aren't they? Chester Cat, I did not miss the super chat, but I paused it for you, just for you, even though I already said I was going to let it play out. You're awesome, man. Thank you.
It's the fact that she's on TV.
All right. Well, hi.
Say hi.
She's cute.
She blew you a kiss, Your Honor.
All right, case dismissed. So I have in front of me a plea agreement. It looks like the misdemeanor. I will dismiss the misdemeanor. It's worth it. And then the defective equipment with an agreed upon fine at $260 to be paid within 30 days.
That's correct, Your Honor. Just so the court knows, I provided Mr. Zick. They did fix, it was warning strips on the back of the truck, and they did replace those. They were faded. So I sent them the proof that they renewed their plate and fixed the defective equipment. So we appreciate the court's acceptance of our agreement.
Okay, so to the that defective equipment count, do you have authority to enter into that on behalf of your client?
Yes, I do, Your Honor. I'm the corporate attorney and I plead responsible.
All right, I'll accept that plea. There's a fine of $260 and your client has 30 days to pay.
Thank you very much, Your Honor. Have a good morning.
All right, thanks. Bye.
Say bye-bye.
Bye-bye. Bye-bye.
I try to make people's days a little brighter. I had a different background on, but she's such a doll. I can't stand it.
Well, it certainly lightened up the docket, so thank you. Have a good day.
Judge Shackleford.
Thanks.
All right. Had to pause it again. Sparkle Pits, thank you for the super chat. Yeah, no, I told you. I wasn't lying that time. And I never lie when I'm telling the truth. You can take that as being truthful. All right. You guys are awesome. I'll see you guys tomorrow. Bye.